Okay, a warm welcome to everyone, and thank you so much for joining me today and for showing interest in my research. It makes me truly happy to see so many of the people whom I've just gotten to know recently, but who have already been so helpful and inspirational. Thank you, Pascal and Lindsay, for organizing today's talk, and thank you, Professor Oltevelt and Professor Liss, for this wonderful opportunity to present my findings as part of the Possibilities for Peace theme. I noticed that it is common to give a land acknowledgement at the beginning of a presentation in Canada, and although being from Germany, this was obviously not something that I've done before, I of course do want to acknowledge that I'm a guest in this country that is built on the traditional territory of the indigenous peoples, the original caretakers of this land, and I acknowledge the historical and ongoing injustices they endure. It is my belief that as a person coming from the continent whose imperialistic and racist policies have profoundly harmed various regions of the world, it is especially important to not only acknowledge, but to do my part in building a peaceful future for all, which of course fits perfectly into Wayfar's theme, and I will be presenting my thesis on the crime of gender persecution to you today. Before I provide the actual legal definitions of gender persecution and take you along my research journey, I would like to use this wonderful mural that I found online to explain the goal and aim of my study in broad brush strokes. Sadly, there are many examples of discriminations against gender groups in the past and in the present, and I fear also in the near future. Examples of the specific targeting of women and girls and LGBTQI+ individuals can be found on every continent. A very prominent example, of course, being the severe oppression of women and girls in Afghanistan by the Taliban. But I've actually decided not to pick a specific case study because I would much rather deliver all-encompassing guidance on how to adjudicate gender persecution in all instances, and because I fear that it would give the impression of excluding or diminishing other examples. The law in general, and also my thesis and this presentation, can be very technical and seemingly almost detached from the lives of human beings. So this is just to acknowledge that we are talking about lives lost, lives harmed, and I want to emphasize that even though the way in which lawyers categorize certain harms sometimes may seem quite technical and cynical even, I truly believe in the potential of international criminal law and the International Criminal Court, as well as domestic frameworks in serving justice and providing recognition for victims' experience. I want to contribute to understanding and utilizing the law in a way that can help reach that goal, even though admittedly such trials will only ever cover a small amount of what happened, as you transitional justice experts know. You would think that given all these gruesome examples of how marginalized gender groups are being treated throughout the world, the crime of gender persecution must have been used countless times to account for gendered harms in legal terms. However, this is not the case. Arguably, the reason for this underrepresentation of the crime in international jurisprudence is that there continue to be misunderstandings around what it means to persecute someone based on their gender and how the crime must be adjudicated. My thesis goal, therefore, is to address these misconceptions. I think it is high time to finally make use of the great potential this crime holds. Now, on to my contents for today and the state of my research. I am, I think, in the final stages of my thesis where I'm questioning, rewriting, etc., but plan to hand in my first draft in September. Naturally, the list of contents, the actual text is long and has many subsections which follow a certain logic that would not be appropriate for today's presentation. I'm therefore planning on delivering an overview of my aim, my methodology, my results, and my conclusion. I hope not to get too technical, but please bear with me if I do at some point. Part of exploring the potential of gender persecution, I think, just means that we really have to dive into it. On to my objectives. Two research questions govern my thesis. The first one is, when is persecution based on gender? And the second one is, when is persecution committed in connection with another crime? As regards the first objective, when we think about what gender means to us, arguably most of us, at least us sitting in this room together, have an inclusive concept in mind, one of fluidity and of intersectionality, and feminist legal theory, as well as many definitions on the UN level, have long left behind the binary frame. A name that must come up, of course, is Judith Butler, with her idea of gender performativity and her groundbreaking work on this complicated notion. We have also heard of Kimberly Crenshaw, whose idea of intersecting identities has become integral to the contemporary understanding of gender. Various UN institutions have adopted quite a progressive approach, and these are the various aspects that are repeatedly emphasized, that gender refers to social attributes and opportunities, relationships between humans, and that it is socially constructed and context or time specific, as well as interchangeable. Now when we look at the definition of the Rome Statute, the law governing the International Criminal Court, we see that it, at least at first glance, is much less complex, and that it has these sort of awkward formulations, the reference to the two sexes, but also the reference to the societal context, and the seemingly redundant second sentence that you can see on the slide. In my thesis, I build on scholars' work, for example, Professor Oosterveld's work, among others, to show that there are convincing arguments that while it is undoubtedly ambiguous and it appears to be a bit of an empty hull, it does encompass the inclusive concept and can cover all kinds of sexual orientation and gender identities. I won't go into the debate or the negotiation process for this definition due to time constraints, but for today's purposes, let's just use this inclusive approach as a working hypothesis. Secondly, we have the concept of persecution as a crime against humanity. The legal conception is essentially severe human rights deprivations on discriminatory grounds. This crime was pivotal in the Nuremberg trial of Nazi leaders after World War II, and it served as the legal qualification of the measures leading up to the actual Holocaust, the murder of 6 million Jews, in absence of the crime of genocide, which is of course very well known to us now, but hadn't been officially acknowledged as its own crime category until the late 1940s. So, persecution encompassed a wide range of policies, measures, inhumane acts, and it is still understood today to encompass a whole variety of acts. Therefore, contrary to other crimes against humanity, its scope, especially the question which acts may amount to persecution, is much more vague and difficult to pin down. Important to note here is that it used to only mean political, racial, or religious discrimination, but since the adoption of the Rome Statute in 1998, it also covers other discrimination forms such as gender-based. So what I'm working with here is two vague concepts, but the potential that I've continuously been talking about in my presentation lies precisely here, in my view. It can cover such a great variety of actions that are carried out for heterosexist and heteronormative reasons. Now on to objective number 2. This is where it gets technical, for which I apologize. I came across these two jurisdictional aspects, which I think are very much worth looking into when thinking about how international trials can properly reflect what is done to people based on gender. The first one regards cumulative convictions, which means that a person is convicted for more than one crime, but based on one and the same action. Many feminist scholars believe that this is an important tool for the reflection of the conduct in the judgment and the sentence. In other words, it ensures that the conviction of the perpetrator actually corresponds with what has happened to the victim. I'll give an example to illustrate how this holds potential for gender-based persecution. I think a very straightforward example for this would be gendered killings. When people are killed on the basis of stereotypes around their role in their society, of course this would be qualified as a murder, as a crime against humanity. The murder charge is self-explanatory and unproblematic in this scenario. However, I would argue that this charge and a conviction only for murder would not actually account for what happened, because the murder was motivated by a form of discrimination. This is arguably a picture-perfect example of gender-based persecution because we have the severest human rights violation on the ground of gender. So to only convict the perpetrator of murder would be insufficient from my point of view. We could apply the crime of gender persecution here and convict them of murder as well as gender persecution. And both crimes are based on the same conduct. This is what I aim to show in my thesis. For today's presentation, I would like to leave it at that and focus on the second jurisdictional avenue because that one is much less explored and a little more complicated. That is the so-called connection requirement. I've already mentioned that the crime of persecution has a wide scope and can encompass various acts of varying gravity. As participants have reported at the conference in 1998, where the ICC was established and its statutory framework adopted, many delegations were concerned about the inclusion of a crime that would have the ability to denote domestic discriminatory practices as crimes against humanity. Therefore, they were in search of a mechanism that would ensure that the court would only be authorized to try the crime of persecution in certain situations. It was generally agreed that those situations should be characterized by a certain level of gravity. Of course, from our perspective as perhaps human rights defenders, when discriminatory measures are carried out in times of peace solely against a state's own citizens, this does not necessarily mean that they are any less worthy of international attention. However, that is essentially what they agreed upon. The offense of persecution in Article 7 contains a clause according to which the persecution has to have been connected to another crime against humanity, or the crime of genocide or war crimes, or the crime of aggression. What exactly such a connection means remains unclear. Does it mean that the perpetrator must have committed several other crimes? Do they have to have occurred simultaneously? What many chambers at the ICC and many commentators have made of this wording is that the court can only adjudicate persecution if the act underlying persecution, in our example from before, that would be the killing, if that amounts to a crime. This would mean that less grave discrimination forms would not come under persecution scope if they don't also qualify as another crime, and this would also mean that the persecutor has to commit that other crime. I highly doubt that this is the only way to interpret this clause, as I will explain in a bit. I suspect that the reason why persecution on the grounds of gender has not been made use of really is not only its conceptual wideness, which I've talked about before, but also because of this conspicuous connection clause. That is why my thesis aim is also to introduce another way to fulfill it, because obviously without satisfying that requirement, the ICC cannot apply the crime of gender persecution in the first place. Now that I've explained what my objectives are, I would like to briefly outline the methodology I've used. I arrived at my findings using the typical methods applied in the field of law. Naturally, I started out with a literature review to gauge what the state of research is, which is also how I identified the gaps that my study is attempting to fill. There's a lot of research on gender and feminist legal theory, and there are many considerations on the crime of persecution, both in the literature as well as in case law. But how these two concepts intersect, that is how gendered norms may be the motivation behind severe discriminations, has been paid much less attention to. Likewise, in international jurisprudence, there are many convictions for rape and other forms of sexual violence, and many convictions for persecution, especially by the International Criminal Tribunal for the former Yugoslavia. But applying a gendered lens to investigating persecution has only just become an objective for the prosecutor at the ICC. In order to fill these gaps that I've identified, I use traditional methods of interpretation, which are also stipulated in the Vienna Convention on the Law of Treaties. According to that, the wording of an international treaty must be primarily interpreted in good faith, along their ordinary meaning and context, and in light of their object and purpose. In order to confirm the results of that interpretation, so-called supplementary means such as travaux préparatoires can be consulted, which in my case are the conference reports, but also the overall history and the origins of the respective clause. Moving on to my findings, this is just a quick overview of the results and the way I've structured my thesis to get there. My dissertation begins with a chapter in which I seek to conceptualize gender and its meaning in international law, and then I move on to conceptualizing gender-based harms. I provide a catalog with explanation of such harms that, importantly, go beyond sexual and gender-based violence, and that many crimes we have considered gender neutral so far can actually be carried out in a gendered manner or for reasons of heteronormativity. The purpose of that section is to provide examples for acts which gender persecution can be applied to. Then I provide an outline of the history of gender as a ground for persecution, which has also, as far as I can tell, not yet been done. I won't go into this too much today, but I argue that while the crime has only been recognized for 27 years, there have, of course, been many instances of gender persecution. And what I find particularly interesting is how courts and feminist commentators have tried to incorporate the gender dimension into other crimes in the absence of gender persecution before it was recognized as a crime against humanity towards the end of the century. Then, as I mentioned, I build on existing notions, especially in feminist scholarship, of how to identify gender as a ground for persecution, and I look into the ICC's and other international tribunals' cases to analyze how they have interpreted and applied the crime. In my thesis, I look at 10 cases at the ICC which involve or involved gender persecution allegations, and I try to identify what point the adjudication of the crime hinges on, why the court has not actually followed through with a single conviction for gender persecution to this date. These steps then enabled me to formulate a definition, which I will introduce you to in a minute. As regards the other part that looks into the jurisdictional avenues, as I said, I would like to focus on the connection between persecution and other crimes, and especially interesting to me is the connection to genocide. As mentioned, persecution cannot in fact be adjudicated at the ICC if it was committed in isolation. But I think that it is not the perpetrator who has to commit another crime. I don't think that's what the connection requirement means. Rather, I argue that it demands the persecution to have occurred with the context of another crime, which of course is completely different from requiring the perpetrator themselves to have committed another crime. I'll actually zoom into two results today, namely those that answer my research questions. When is persecution committed on the ground of gender, and when is persecution connected to another crime? I feel those were the most difficult points of my study, as well as the core areas in which I'm hoping to actually contribute to international criminal law research. This is the definition I propose for persecution on gender grounds. My goal is to deliver a sort of guidelines on how to identify gender persecution. So, in my opinion, persecution on the ground of gender means the targeting of one or more individuals by the perpetrator because of the perpetrator's beliefs around what it means to be male or female in the context of the perpetrator's society. These acts of targeting either accompany the commitment of other crimes or the very act itself expresses such beliefs. In both cases, the underlying act is usually carried out for the purpose of punishment for perceived deviation from the perpetrator's constructions because of a perceived lesser social status of the victim and or in order to reaffirm the perpetrator's dominant societal position. Professor Oosterveld's comment on this definition was really helpful actually. She suggested repeating the word perpetrator to emphasize that it is their stance that matters. So thank you again for that. I also go into the whole question of how to substantiate gender persecution allegations, how to put theory into practice, so to speak, but I have left that part out for today's purposes. What has also fed my considerations to a substantial degree was international refugee law, given that gender-related persecution has long been a recognized concept in that field, and there are many lessons to be learned from there. Governing my understanding of how gender can function as a ground for persecution is something I've learned to be called the post-categorical approach from anti-discrimination law. It is the idea, put in simple terms, that we should stop trying to categorize victims and move beyond the notion of grouping or boxing them. Instead, the law and law practitioners should focus on the perpetrator's perspective and ask what constructs could have motivated the commission of the crime. I transplanted this notion to my study and suggested that we should understand the crime of gender persecution not as criminalizing targeting people because of their gender. This gives the impression of necessitating an assessment of what the gender of the victim was, which is really not what the offense requires. Rather, I think we should understand the crime as penalizing heteronormative or heterosexist discrimination. It is therefore the discrimination form we have to identify, and not the alleged gender identity of the victim. The second crucial result of my study relates to the connection between persecution and other crimes. As I have pointed towards earlier, I was especially interested in how to link persecution to genocide because there is this gap in terms of protection in the genocide definition, given that it does not explicitly protect gender groups. There must always be an intent to destroy a national, ethnic, racial, or religious group in order for it to be legally qualified as genocide. Many have criticized this, and there are continuous calls for its amendment. There's this one famous international criminal law scholar. He's also one of the most authoritative scholars, I think, William Shavis, who said that the codification of persecution and its much more widespread ambit of discrimination forms is actually the widening of the genocide definition that many have called for all these years. I was interested to look into that. As I said, I understand the connection requirement for persecution to mean that it has to have occurred in the context of another crime. Hence, I was looking for a way to establish that a persecutory act took place in the context of genocide, and I looked into applying the contextual element of genocide to that connection. The contextual element was inserted in the elements of the Rome Statute to hinder the ICC from adjudicating isolated acts of genocide carried out by a single perpetrator. It stipulates that there must have been a manifest pattern of similar conduct against a national, ethnic, racial, or religious group. I don't want to delve into this too much because it gets really complicated at this point, but I do want to share with you that my solution to the issue of how to place persecution in the context of genocide is to employ the contextual element. What I'm trying to convey with this awkward diagram is that the persecution must fulfill that contextual element, which entails that it has to have been committed against one of the group the genocide definition protects. But it can nonetheless be carried out for heteronormative reasons. Take the example of persons being singled out and killed as punishment for perceived deviation of the gender norm. If they're also from the same distinct national, ethnic, racial, or religious group, I suggest employing this connection to actually reflect their targeting for heteronormative reasons. I want to add, even though I'm focusing on the relation to genocide today, and as I said, it is in fact what I'm most interested in because frankly no one else seems to be, I introduce ways to connect persecution to the other crimes too, namely war crimes and other crimes against humanity. But the core takeaway from this part should be that the connection requirement should not be very limiting, because all it means, in my opinion, is that the persecution must have been committed in the context of another crime or be accompanied by another inhumane act, and that these crimes must have occurred but not committed by the same perpetrator. While this clause has been criticized by many, in my opinion, it could actually be useful in that it can reflect the purpose for which many gender-based acts of violence are perpetrated in genocidal contexts. For instance, it can be a tool to reflect forced marriages or very other forms of gendered oppression women face, additional to the genocidal acts. They're often a piece in the puzzle that form the genocide, and I think that this jurisdictional connection would truly serve to acknowledge that dimension. The same goes for the specific targeting of LGBTQI+ persons in genocides. Without this connection, we either have a conviction for genocide, which would not explicitly account for the gendered aspects, or, for example, a conviction for sexual violence as a crime against humanity, which would in turn not account for the specific intent to destroy the whole community. I'm hoping that this tool will help to make that link in the legal sense and to contribute to serve justice for those who are harmed based on heteronormative discrimination. I would like to end my presentation with this powerful quote from Nadia Murad, Yazidi survivor, human rights activist, and Nobel Prize winner. I'm sure many of you know her. I think she will unfortunately not be the last girl to endure what she has gone through, but I think that it is always worth fighting on and making use of the tools that we have. Thank you for being here and for listening.